Hello students, there is a good news for you. Now you can write the same matter at different speeds. Link of the same is given in the description box. Thank you. Start. Two persons were working as coal cutter in the company. Stop. According to the management, they were guilty of several lapses. Stop. They were served with a charge sheet with the charges that they have participated in a strike and made picketing in front of additional chief manager, confining him in his office, and they, along with other workmen, abused the chief manager in filthy language. Stop. They raised slogans and abused the officer along with others. Stop. They also led a procession with the effigy of the manager and attempted to burn the same, and they have broken the gate with an intention to do physical harm. Stop. They stopped all the workmen from going to the work and indulged in a strike, and these acts constitute violation of subsection 1 of section 22 of the Industrial Disputes Act, and that it amounts to serious misconduct under the standing orders. Stop. Para. The petitioners were given 3 days' time to submit their explanations. Stop. They were also asked to appear for inquiry. Stop. The petitioners submitted their explanation denying the charges. Stop. An inquiry was conducted and the petitioners were found to be guilty and they were dismissed from service by proceedings. Stop. Para. The petitioners raised an industrial dispute and the matter was referred under sections 7A and 10 of the Industrial Disputes Act to the Industrial Tribunal, Hyderabad for adjudication. Stop. Para. Before the tribunal, the workmen contended that the order of dismissal was invalid and the findings of the inquiry officer are perverse and erroneous. Stop. The matter was contested by the management supporting the action of dismissal. Stop. Para. A preliminary objection was raised that the inquiry is vitiated by non-observance of the principles of natural justice, and this objection was overruled by order. Stop. The tribunal held that the domestic inquiry was held properly and there was no any violation of principles of natural justice. Stop. Para. No oral evidence was adduced before the tribunal, but the workmen filed 3 documents is a judgment on the file of Judicial Magistrate First Class, in which the 2 petitioners and 13 others were charged under sections 147, 448 and 506 IPC. Stop. The workmen were acquitted of all the charges. Stop. Para. On a consideration of the material on record, the tribunal held that the order of dismissal is not justified, particularly in view of the fact that the criminal court had passed an order of acquittal in respect of the very same charges, and even on merits the dismissal is not justified. Stop. It is the validity of this order that is challenged in this writ petition. Stop. Para. The learned counsel for the management mainly contended that the award is vitiated by an illegality inasmuch as the tribunal proceeded on the footing that all the incidents covered only one incident adjudicated by the criminal court. Stop. He submitted that criminal case covered only one incident relating to burning of the effigy of the manager and trespass into the premises. Stop. The other charges were not the subject matter of the criminal case. Stop. The incident alleged to have taken place on June 23, 1983, and the strike conducted was not the subject matter of the criminal case. Stop. The industrial tribunal proceeded on a wrong impression that all the charges were the subject matter of criminal prosecution and the workmen were acquitted. Stop. This approach had vitiated the entire order. Stop. Therefore, it is liable to be set aside. Stop. He further submitted that the industrial tribunal has no jurisdiction to reappraise the evidence and come to a different conclusion on merits. Stop. Having found that the domestic inquiry was conducted properly, the tribunal erroneously considered the evidence as if it is an appellate authority and recorded its own findings on merits which are not permissible. Stop. The industrial tribunal has only power to modify the punishment of it is of the opinion that it is disproportionate to the charges leveled against the workmen. Stop. But it cannot go beyond that power. Stop. Para. On the other hand, it is argued by learned counsel for the workmen that the charges levelled against the workmen are substantially covered the criminal court's judgment in which the workmen were acquitted of all the charges. Stop. He further submitted that the tribunal did not rest its decision only on that point. Stop. The tribunal considered the evidence and the material on record and found that the dismissal is not justified, and with the introduction of section 11A in the Industrial Disputes Act, the Labour Court or the Industrial Tribunal has ample power to go into the questions of fact and satisfy itself about the justification of the dismissal order. Stop. It can also consider whether the punishment imposed is reasonable having regard to the gravity of the charges. Stop.